Hello, everyone. Welcome and thank you for attending today's webinar, which is the next installment of our non-for-profit fireside chat series. We're calling this one Ask the Nonprofit Attorney, and it features Jeff Tannenbaum. I'm delighted to be joined by Jeff today and my colleague, Pat McGowan, who will moderate today's presentation. Thank you both for being here, and a special thank you to you, Jeff, for your willingness to support our clients, contacts, and the sector by joining us today. A little bit about myself. I'm John Alfonso, a CohnReznick partner and the leader of our non-for-profit and education practice. I devoted most of my nearly 40 years in public accounting to serving non-for-profit organizations. I'm very proud of our firm's longstanding commitment to the sector, and I'm especially proud of my colleagues who devote their time and talents to serving non-for-profit clients and supporting the communities in which they work. One of the organizations I support and have been involved with for many, many years is the American Cancer Society. I've served as chair of the Society's board of directors in 2021, which was a real honor of a lifetime. I'm also honored to serve on the Financial Accounting Standards Board's not-for-profit advisory committee through 2024. So before we begin the webinar, I'd like to share a few housekeeping items with you. There is no dial-in number for this webinar, as the audio portion is being streamed through your computer speakers. So please be sure your computer speakers or the headset are turned on and the volume is up. If you have any questions during the webinar, you can submit them through the Q&A widget. The presentation slides are available for download at any time during the webinar. There are a number of application widgets at the bottom of your screen. All the widgets are resizable and movable, so feel free to move them around. Your CPE certificate will be available for immediate download via the software, assuming you have viewed the webinar for at least 50 minutes and responded to 75 of the attendance checks. We recommend using Google Chrome as your web browser for this webinar. And finally, if you experience any type of delay, try pushing F5 on your keyboard to refresh the page. Just as a reminder, this presentation should not be substituted for consulting directly with your attorneys, your accounting professionals, and/or business advisors to discuss your specific situation. As I'm sure you're all aware, CohnReznick is a CPA firm. We are not practicing law, and as such, we are not giving you legal advice today. Let me introduce Pat and Jeff to you. So Pat is a CohnReznick partner and leads the non-for-profit and education industry practice in New England for the firm. She also leads our national higher ed practice. She has spent her entire 30-plus years focused on working on all types of non-for-profit organizations, including higher education institutions, social service organizations, developers of affordable housing, arts and cultural organizations, independent schools, and private and community foundations. Pat takes a holistic approach with her not-for-profit clients. Aside from performing financial and compliance audits, Pat works with management boards to ensure that our clients are financially sustainable and they have financial reporting systems that are efficient and effective. Education of our clients and our staff is one of Pat's top priorities. She lectures on various non-for-profit issues and is responsible for authoring articles and alerts. Internally, she has been responsible for developing CohnReznick's national non-for-profit continuing education curriculum. She often serves as a national instructor with CohnReznick's leadership and development team. I'm delighted to introduce you to our guest speaker today, Jeff Tannenbaum. Jeff is a very well-known non-for-profit attorney, as well as an accomplished author, lecturer, commentator, and expert witness on nonprofit legal matters. He is the managing partner of the Washington, D.C.-based Tannenbaum Law Group, a 5-attorney boutique law firm focused exclusively on the legal needs of non-for-profits. Jeff counsels his clients on the board on the broad array of legal and sensitive business and governance issues affecting non-for-profit organizations. Jeff was the 2006 recipient of the American Bar Association's Outstanding Non-for-Profit Lawyer of the Year Award. He is one of only 5 lawyers in the prestigious U.S. Legal's 500's Non-for-Profit Hall of Fame, and he has been ranked as a best lawyer for non-for-profit charities law nationally by U.S. News and World Report ever since 2012. Jeff is the author of the American Society of Association Executives published book, Association Tax Compliance Guide, which, according to him, is only slightly more popular than a second book, Quarantine Cocktails. And Jeff, I'm going to add that to my book reading list. He currently serves as chair of the American Bar Association's Trade and Professional Association Subcommittee and on ASAE's Legal Advisory Council and Public Policy Committee. So thank you both for joining us. And without further ado, I'm going to hand it over to Pat.
Great. Thank you, John. I'm very excited to be here today with you, Jeff. And just to give everybody some perspective, this is really Q&A through the whole thing. We have a number of questions that many of you have submitted to us prior to the event, but we would also ask you to put questions in throughout the presentation into the Q&A widget, and we will be moderating them as well. What I'm going to do, Jeff, if it's okay, I'm just going to start rattling off some questions and we will go through. So the first few are going to be mostly focused around corporate governance types of issues. So the first question is, should a CEO of a nonprofit be a member of the board of directors?
Thank you, Liz. And John, thanks for the kind introduction. And just so everyone is aware, so that we can try to get through as many of these questions as possible over the next 50 minutes or so, I'm going to obviously have to keep the answers relatively brief. Some are going to be a little bit longer. It's going to be a bit rapid fire. Your heads are going to be spinning by the end of the hour for sure. But we want to try to cover as many different issues and topics and deal with your questions to the greatest extent possible. So should a CEO of a nonprofit be a member of the board? So, first off, we first look to the law, the things like the state nonprofit corporation law of the state of incorporation to say, who are the officers, what officers are required of the organization, how do officers get designated, elected, things like that. Then, of course, you look to the bylaws for the same thing, and the bylaws have to be consistent with the state law. There's really no, right or wrong from a legal perspective on this question, but I will say from my experience, and I've been doing this for 28 years, it is a best practice to have the CEO be an ex officio non-voting member of the board. So ex officio means by virtue of their office. So whoever serves in that CEO / executive director / president and CEO, whatever the title is, the chief staff executive. In my opinion, it's a best practice to have that person ex officio serve as a member of the board. But ex officio board members, they're full board members, but they can either be voting or non-voting, and you always have to specify. A lot of people think that ex officio by definition means non-voting. It doesn't. But in my experience, it seems to be a more common and a best practice to have the CEO be an ex officio non-voting member of the board, and the same with the executive committee, presuming the organization has an executive committee. It's really important in my experience to have that CEO kind of be in the room, I just spent 3 hours this morning at a trade association client board meeting there for antitrust monitoring purposes. And in that association that I go to probably 3 board meetings a year, the CEO is always there, and the CEO is an intimate part of all of the discussions. And of course, when the board or the executive committee is discussing the CEO's performance, the CEO leaves the room, whether it's in person or virtual. That person recuses himself. But the rest of the time, in my opinion, the CEO should be there, but be a non-voting member of the board.
Great. Thanks, Jeff. Following up on that, moving to another member of the board is the treasurer specifically, and whether the treasurer can and or should be compensated for their role, or should they be a volunteer, or could they be a paid employee?
So it's a good question, Liz, and it kind of dovetails off the last one. So, and I actually wanted to say this, so this is perfect. In my experience, it's really important, in addition for the CEO to be an ex officio non-voting member of the board, for the CEO to also be listed in the bylaws as an officer. There are many forms, documents, legal submissions that require a signature of an officer. And I have seen over the years some of our clients where the executive director, for instance, if that's the title, is not an actual officer. And the staff is constantly running around to all the volunteer officers to get them to sign documents and things like that. It's not efficient. It's not necessary. And in my opinion, it's a best practice for the CEO or executive director to be an officer. Now, when it comes to the treasurer, and most of the state nonprofit corporation acts say that you, at a minimum, you have to have two officers, a president and a treasurer. Most of the laws, like DC, say that that role, that office, cannot be held by the same person. Some states require a secretary as well. Many, like DC, allow the secretary-treasurer position to be combined. Now, all of that being said, and of course, you want to make sure that your bylaws are compliant with the state law and they spell out who the officers are. But this one, when it comes to the treasurer, which is always a required officer, is in every state that I'm aware of, it doesn't have to be the volunteer treasurer. It could be the CFO. So for some of our clients, and we have probably about 750 clients, some of them, the treasurer, the CFO is the treasurer. But I would say more commonly, the treasurer is a volunteer leader and an officer. But then if the CFO, if there is a CFO, some nonprofits don't have a CFO. But if there is one, that CFO should be an officer as well. Just the fact that CFO has officer on the title doesn't make them a legal officer. Same with CEO. You have to actually specify that in the bylaws. So can the CFO be a treasurer and a paid employee? Yes. But I'd say it's more of a best practice to have the treasurer be the volunteer leader treasurer, so that there's this checks and balances oversight over whoever is the CFO or the controller, over the CEO. And that's my experience.
Great. Thanks for that. Going towards committees a little bit more, and considering the challenges of recruiting new audit committee members, which I think most organizations can say can be challenging, are there pros and cons of having a separate audit committee versus a combined finance and audit committee?
Yeah, that's a good question, Pat. So it really, my experience depends on the size of the organization. We represent some of the largest nonprofits in the country. We represent a lot of medium-sized ones, and I've represented some very small ones. In a small and even a medium-sized nonprofit organization, there's often not enough volunteer leaders, not enough board members. Now, granted, all of these committee members don't have to be board members if they don't want it. If you don't want them to be able to exercise the fiduciary duty of the board, they don't have to be comprised solely of board members. Although if you want them to be able to exercise fiduciary responsibility and have the board delegate fiduciary responsibility, in most states, they have to be comprised solely of board members. So it depends on the size of your board. If you have a 30-person board or a 40-person board, you're going to have enough people to populate perhaps a separate audit and a finance committee. In my view, in a perfect world, from kind of an internal controls, checks and balance perspective, it would be ideal to have a separate audit committee that's separate and distinct from the finance committee. But so many nonprofits just don't have enough volunteers to populate two separate committees, so they have to combine the functions. And from a purely legal perspective, there's no problem with that. It doesn't violate the law. Now, there are, granted, in some states, like for instance, California and New York, if you're incorporated there, and depending on the type of nonprofit you are, those states have certain requirements that you have, like an audit committee that has certain independent folks on it, and that's mandated by statute. But if you're not incorporated in those states, most other states don't regulate that. And so, again, ideally, having two separate committees would be ideal, but it's really hard to do in most nonprofits.
Okay. And just adding a follow-up that came through, what about an investment committee? Should that be separate? Can they be combined?
Yeah, and it's really the same answer. If you have enough people, having the investment committee just focus on investments, it's great. But look, there are so many nonprofits, they got audit, finance, investment, all combined into one committee. But that being said, I do think it's important through committee charters to have those functions allocated, even if it's one committee, so that you're not doing all of this work at the board level. You want to utilize committees effectively so that you can let them drill down on all of the nitty gritty and the developing and approving, recommending the budget to the board, and meeting with the auditors, reviewing the draft audit of the external financial statements. working on the investment policy statement, analyzing the investment manager's performance, making changes as appropriate. You want those things to be done at the committee level so that the board can be focused on more big picture, strategic, higher level, important issues, and let the committees drill down on the details.
Great. Which leads a little bit to the board and the board members. And what does happen if you don't have 3 independent board members?
Yes, I'm not sure where this question was coming from, but by independent, what most people mean is non-compensated, like not staff. And I would say in the nonprofit world, it is absolutely a best practice to have a board that is at least a majority of which are not compensated folks. There's no question about that. And again, with a couple of, maybe a few exceptions in certain states, that's not a legal requirement, but it is a best practice. And number 2, from an IRS perspective, well, the IRS doesn't mandate this. They do ask on the 990 about whether board members receive compensation. And if they see a 990 that has, majority of the board members all receiving compensation, that's going to be a big red flag from their perspective, from a private inurement, and if you're C3 or C4 private benefit perspective. And it's, as we all know, a very publicly available document. It's not going to look good to potential donors, funders, grantors, et cetera, if you have, say, majority of your board who are compensated by the organization.
We've got several questions relating to contracting and really who can and should be signing contracts. So a couple of questions have been looked at in a different way. One is, can the executive director or CEO be signing contracts, or should the board be signing those contracts?
Great question, Pat. Let me just add one postscript to the last question.
Sure.
I want to make sure I was clear, because I mentioned that some states, including New York and California, have certain requirements for audit committees, and they also have certain requirements when it comes to boards. And I'm guessing that's where that question about the 3 independent board members came from. But if you're not subject to the laws of California and New York, which generally means you're not incorporated there, although sometimes you can be subject to those laws for other reasons. In most other states, that's not a state corporate law issue, but it certainly is an issue from an IRS and a public perception perspective. So your question, Pat, sorry, just refresh my memory for 2 seconds. You don't have to read it all.
Sure, absolutely. It's actually in regards to signing contracts.
Oh,
so,
contract.
Yeah.
I got it. So here's the thing. It's really important that the board of any nonprofit adopts certain core policies. There's a number of really core policies. Some of them the IRS asks about on the Form 990. Has your board adopted a conflict of interest policy, a whistleblower protection policy, a record retention policy, et cetera? And some the IRS doesn't ask about, but they're equally important. Check signing authority, which sometimes get combined into what's called a procurement policy. So sometimes those two get combined into a same policy. Sometimes they're separate. And not many nonprofits issue actual checks, but a lot of people still refer to it as a check signing authority. But you know what I mean, the ability to authorize the expenditure of funds. It's really, really important that the board give a lot of thought, maybe have them working through the finance committee first and coming to the board with a very thoughtful proposed policy that governs those things, one or more policies, however you want to do it. And it should make clear, at the board meeting I was at this morning, they revised their policy regarding investments to allow the new CFO to have the authority to move things around in investment accounts in certain circumstances. That's pursuant to a policy. So you always want to be clear, who has the authority to sign, to authorize expenditures up to certain dollar amounts, who has the authority to sign contracts. A procurement policy will go further and often say, like, for any acquisition of goods or services over, $10,000, unless you can make a special, argue for a special exception, you have to do an RFP, get at least 3 bidders, things like that. These are all part of good governance procedures. You also never want to have just one person who has contract signing authority or check signing authority. In most nonprofits, you certainly don't want just volunteer board members to have that authority. In fact, generally, the authority is going to be limited to staff. But sometimes the policy might require that you get prior authorization for certain types of transactions from the board or the executive committee, things like that. So this is too short of a session to go into all of that detail. But my point is, give it some real thought, think through as an organization grows, that policy is probably going to need to change. You want to have alternative people, but you want to have checks and balances for certain large expenditures. You want to have dual signature approvals for certain expenditures, two people signing the check, so to speak. All of that should be baked into your policies.
So then the obvious follow-up to that that's come through also is, what if we haven't been following what either the bylaws say or our policy says? The executive director has been signing things. That's not what the current organizational guidance has said. What do we do going forward?
Well, two things. First, obviously, start doing things pursuant to your policy or policies going forward. That goes without saying. But secondly, having the board ratify the approval of prior contracts that were signed by the person who was not authorized to sign them, and not just some blanket resolution that says, we board of directors hereby, ratify and approve all contracts that were signed by the executive director in the last 3 years. You want to actually have a list of them, names of them, dates, things like that. Attach copies of them to the board book and whatnot, and then the board can retroactively ratify them.
That's great. Thank you. Switching topics briefly, a little bit more towards tax, and certainly in this world of an election year, the question of political contributions always comes up. So for in your perspective, in the year of an election, can a nonprofit make political contributions to federal and state candidates? And if so, how?
Oh boy. Yeah. So this is a very complicated answer. Let me try to simplify it. So first off, I want to take a step back. We got to distinguish between lobbying activity and political campaign activity, because depending on the type of tax exempt organization you are in, and I hope everyone understands the difference between a nonprofit corporation and a tax exempt organization. One is a function of state corporate law, one's a function of federal tax and tax exemption law. But for tax exempt organizations, depending on the type of organization you are, for instance, 501c3, 501c4, or 501c6 organization, there are different tax rules that come into play. So for instance, 501c3s are banned from engaging in any political campaign activity. That means supporting or opposing candidates for public office. But they are allowed to engage in lobbying activity, which under one of the two sets of definitions for C3s means legislative lobbying at the federal, state, or local levels. But then in terms of political campaign activity, like supporting candidates, making political campaign contributions, PAC contributions, these are also regulated at the federal level by the Federal Election Commission under federal election law. And then at the state level, every state has their own state election laws. And so, for instance, like from a state level, I'm in DC, but in neighboring Virginia, it is lawful for corporations to make contributions to political candidates and PACs. That's not the case in DC. That's not the case in Maryland. But that's just under state election law. And this is obviously for state campaigns like governor, state house, things like that. At the federal level, if you're a 501c3 organization, even though you are a nonprofit corporation, and if you want to make a contribution to a Virginia political candidate, you can't, because C3s from a federal tax law perspective are banned from engaging in any political campaign activity. So short answer is you got to look to whether it's state or federal, look at what the federal state election laws say about who and like even federal election law in the states. It's very highly regulated as well in terms of who can make contributions and how much and up to what limits. And generally a different limit for the primary and the general election. There's reporting of all of that information, et cetera. So you look to state and federal election law, and then you look to your tax exempt status. So for instance, 501c4s and 501c6s, they can engage in unlimited lobbying activity as long as it's related to your mission and purpose. But in terms of political campaign activity, it can only constitute up to half of their overall activity. So you got to factor all of those things when you're doing that analysis.
Which happens to allow me a perfect segue to another question, which came in today, which was, can you have a discussion, and we'll say that in a short discussion about the 501H election and who should be considering that or not? I know that's hard to do in a quick response.
No, I can summarize it. And by the way, John, if you or Pat or someone could, or Liz can put into the Q&A for everyone a couple links, because I should have mentioned this earlier, but a lot of the stuff I'm talking about, we have articles and recorded webinars on our website. Our website is tenenbaumlegal.com, tenenbaumlegal.com. And if you look into the resources tab, there's a sub-tab for publications and there's one for recordings. And we have articles on almost everything I've been talking about so far, and especially some really good ones by my colleague Susan and myself on lobbying rules for C3. So encourage you, way more than I can talk about here today, take a look at those resources. But for C3s, ever since 1970 of the federal tax code, C3 organizations have had the ability to make what's called the 501H election. And that means you elect by filing this really simple form. I think it's 5768 or something. You file this half-page form with the IRS one time, and that means you are electing to be governed by the 501H election rules. Now, generally speaking, for any C3s other than very large ones, it's almost a no-brainer to make the 501H election because it has a very clear definition of what's lobbying. It has quite a number of exceptions built in. It makes clear that we're only talking about lobbying only means legislative lobbying, not regulatory lobbying. It also makes clear that we're only talking about dollars spent, like staff time, outside lobbyists, not volunteer time. And there's also very clear limits. And even if you exceed the limits, there's a series of penalty taxes that can be assessed, but you have to really exceed the limits significantly over a 4-year average period in order to threaten your tax exempt status. Whereas if you don't make the election, then you're governed by what's called the no substantial part test, which has no rules and no definitions, and it's very vague and it's very unclear. And the only penalty for violating it is revocation of tax exempt status. And so the one thing about the 501H election, though, there's an annual global cap on lobbying expenditures of $1 million a year. That has been in the law for decades, and it has never changed. It's not likely going to change anytime soon. Has not gone up with inflation. And so if you're a very large nonprofit, that's got a $20 million or more budget, and you want to spend $3 million a year on lobbying, the 501H election doesn't work. And so it's generally only C3s that are very large like that decide to be governed by the no substantial part test and not make the election. But if you can stay within $1 million of lobbying a year, then absolutely make the 501H election. And then last point from a planning perspective, of course, C3s and the U.S. Supreme Court, maybe 25 years ago in a court case, kind of endorsed this structure, this construct, where a C3 can set up an affiliated, controlled C4, 501c4 affiliate. And there are many, many across town here in D.C. and elsewhere, kind of these C3, C4 kind of sister entities that they can have some overlapping board members. They can do certain things together, but they have to have independent funding. The C4 has to have its own independent funding sources. But then as a C4, as I said a few minutes ago, you can engage in unlimited lobbying activities. You don't have to worry about 501H election or not. So keep that in mind from a planning perspective.
Great. Thanks. A more general question a little bit on what are you seeing in regards to the IRS audits of nonprofit organizations? Are they out there? What is the IRS looking at generally?
Well, I will say I felt fortunate in the 28 years that I've been practicing law to having represented tax-exempt organizations, primarily C3s, and a few C6s in probably 75 different IRS audits or appeals. That doesn't happen anymore. It's been quite a while since I've been involved in an audit, and it's been quite a while since the fellow members of the nonprofit bar, we compare notes on this stuff. And the IRS just is not doing many audits of exempt organizations. They've gone way down. Now, they have gotten a fairly recent, as I'm sure you've heard in the news, boost in funding that might lead to an increase, and some people think it will lead to an increase in audits of exempt organizations. In recent years, there hasn't been that much enforcement in this area. That being said, it's not a blanket excuse or blank check to violate the nonprofit tax laws. And while some audits are random, other audits are initiated because the IRS has some pretty sophisticated software they use to analyze Form 990s and see things that look unusual or off kilter or not typical. That can trigger an audit. News reports, enforcement actions from like state attorneys general and others can trigger enforcement actions. News stories. There's kind of a hotline where people can file complaints about tax-exempt noncompliance. And so there are a lot of different ways that IRS audits can occur, and you always want to be on guard for that. And with the consequence potentially of being loss of tax-exempt status, revocation of tax-exempt status, which is kind of the death penalty for most tax-exempt organizations, it's something you have to take seriously.
Yeah, absolutely. Thank you for that. Changing direction a little bit and looking at structuring. So a lot of organizations are looking to diversify their revenue, and therefore they're getting into some other types of mission-related or sometimes non-mission-related activities. What would be your best practice or your thought process about when to create a subsidiary for the organization and or to perform those different activities within the nonprofit itself?
Okay, so I've always worked with hundreds and hundreds, or probably thousands at this point, of nonprofit tax-exempt organizations in connection with these sorts of issues, kind of the tax planning and business planning part of it. First off, in my experience, the most successful nonprofit tax-exempt organizations are ones that think outside the box. They're creative, they're aggressive, they're always coming up with new ideas, new revenue sources. Sometimes they're mission related. Sometimes they clearly generate tax exempt revenue because they're substantially related to the mission and purpose of the organization. Sometimes they're not. There's think some very successful group purchasing programs or other things that will generally generate unrelated business income. And you always, of course, want to try to do everything you can to take advantage of the 3-part unrelated business income tax or UBIT test. Which says that if you have a regularly carried on business activity that's not substantially related to your mission and purpose, it's generally going to generate unrelated business income, which is going to be taxable at the federal and state corporate income tax rates. However, there are numerous exceptions to UBIT. Some of the more notable ones for this group on the call on the webinar today are the exceptions for royalties, for qualified corporate sponsorship payments, for qualified convention and trade show payments, for dividends, interest, annuities, rent, capital gains. And so you always want to take advantage of these exceptions to the extent possible. There's a pretty recent article of mine about unrelated business income tax and nonprofits. It gives a pretty thorough overview of all of these issues and does a deeper dive into the royalty exception and the corporate sponsorship exception. Take a look at that because sometimes, for instance, depending on what benefits the sponsor is looking for, you might be able to turn what is otherwise a taxable advertising payment into a tax-free corporate sponsorship payment. And the sponsor / advertiser, whatever you want to call it, depending on what bucket it falls in, might not really care about certain benefits. And you might be able to take out some price information or endorsement type language or any sort of qualitative information and turn it into a qualified corporate sponsorship payment, which is then all tax-free on an unlimited basis. So take advantage of that. And then, as I've always told clients, don't let the tax laws be the tail that wags the dog. If you come up with a great revenue generating idea, and there's no way to get it outside of the UBIT bucket, it's going to have to be taxable income. You always have the option to form a wholly owned taxable subsidiary, a for-profit company that is wholly owned by the tax-exempt organization. Well established, there's tons and tons of nonprofit organizations that have taxable subsidiaries. The taxable subsidiary can engage in any activity it wants. Of course, it's going to pay federal and state corporate income tax on its net income. Net income is important because sometimes there might not be a lot of net income. But then after-tax profits can be paid up to the tax-exempt organization in the form of dividends on an unlimited basis, and all of that is tax-free to the parent. So if you've stumbled upon some great idea, and there have been plenty of nonprofits that have, and they go out, they form a taxable subsidiary, they capitalize it with a lot of money. They sometimes go out and find other investors to grow it even more, then sometimes later sell it. There's some great examples of some very great success stories of nonprofits, some of which I've worked with, on doing things like that. Don't run away from it. Pursue it, but just be safe and protect your nonprofit's tax-exempt status by using a taxable subsidiary.
Great. Which leads to a question on the reverse side. So for an organization that has an obsolete 501c3 organization for whatever reason, what is the process for actually closing one of those out, whether it relates to the IRS, the state filing, regulatory requirements?
I'll get to that in 1 second, Pat. Let me just, John just fed me a follow-up question from someone in the audience. I get the question a lot of how much unrelated business income can a tax-exempt organization earn before it puts its tax-exempt status at risk. There is no IRS or statutory hard and fast right line here, but what I and my colleagues have always advised our clients is that if your total from all sources, gross unrelated business income for the year starts to approximate 15 to 20% of your total gross income, that's when you're probably approaching a danger zone and you want to consider shifting some or all of those activities into a taxable subsidiary. Now, as to your question, I get this issue a lot. You know, a client last week was talking to me about a kind of a dormant, they're a 501c6 trade association. They have a dormant 501c3 foundation that's really not doing anything, but they have plans to revitalize it. And they have some really good ideas for using it for fundraising. And they have smartly kind of kept it alive, very easy to do. You know, file your annual report with your state of incorporation. If you're qualified to do business in a state other than your state of incorporation, file your annual report there. File your Form 990, even if it's the Form 990, the 990EZ, or the 990N, depending on the size of the organization. File that with the IRS each year. And if you're in a state that has state corporate income tax, file it there for your state corporate income tax exemption. Do those basic filings, hold an annual meeting of the board just to keep it alive. But you don't have to run any activities through it. It's so easy and inexpensive to do, relatively inexpensive, that to me, it just makes a lot of sense as opposed to starting all over, forming a brand new nonprofit corporation, going and filing a new tax exemption application with the IRS, things like that. But if for whatever reason you decide, we just don't need this nonprofit affiliate or this for-profit subsidiary anymore, the process for dissolution is actually pretty simple. The dissolution process is a function of state law. So wherever you're incorporated, you got to follow the procedures of the state. It's going to be, if it's a nonprofit, it'll be reflected in the state nonprofit corporation statute. If it's a for-profit, it'll be in the for-profit corporation statute. Follow the procedures. But in most states, it basically just means filing, having the board, and if there are voting members, the members have to approve it as well. Articles of dissolution, as well as a plan of distribution saying where any remaining assets will go. From an IRS perspective, if it's an exempt organization, they have to go either to another tax-exempt organization with the same category or a consistent category, like a C6 can give money to a C3. If it's a C3, it has to go to another C3 or a governmental agency. And then you file the articles of dissolution with the state. That's what legally dissolves the entity. And you file your final Form 990 with the IRS. You mark it as your final Form 990. We usually attach a copy of the certificate of dissolution, and then file the final one with your state if you have state corporate income tax exemption as well. So it's not a particularly difficult process, but anyway, that's the answer.
Okay, great. There was a follow-up question relating to the IRS audits that I thought was timely, which was whether you're seeing increased reviews of employee retention credit and PPP loan forgiveness by the IRS.
What do you say? Have I seen more audits?
Or just reviews thereof? Obviously, there's things in the public space out there about the IRS's perspective on some of this, but just
anecdotally, I've heard actually really only about one, and it was actually I've heard of one on the ERC side, employee retention tax credit, and one on the PPP loan forgiveness side. But I wouldn't say I've seen that as a big trend in the tax exempt community. I've read about it more in kind of the small business community. But anyway, I don't think I have enough information to really help on that.
Okay, thanks. Changing topic once again a little bit. AI is also a conversation that's out there quite a bit. So we had a couple of questions there about how nonprofits should be looking at AI and what might be their focus on risks and mitigating risks around AI or the use of AI. And have you been dealing with this at all?
I have been dealing with it quite a bit, but I want to answer one question that someone posed that's kind of related to what we just talked about. You might have heard me, and I intentionally referred to your state of incorporation versus state where you're located, where you have to what's called qualify to do business as a foreign corporation, meaning you're incorporated somewhere else. Now, of course, if you're like headquartered in Illinois and you're incorporated in DC, then you have to qualify to do business in Illinois, maintain a registered agent there as well, and similarly maintain a registered agent and file your reports in DC as well. But with remote work having taken off so incredibly much since 2020, there are so many nonprofits that have employees working in many different states. We have some clients that have employees working in 40 different states. Not uncommon to have employees working in 10, 15 different states. And just like if you have an office in a state, if you have an employee working in a state, that also triggers a requirement to qualify to do business as a foreign corporation. File that form, pay the fee, get a registered agent, and then file the annual report with the state. And you have to do this in every state where you have an employee. And then, of course, on top of that, there are a lot of other requirements that you have to register with the state tax authority for all sorts of payroll taxes and withholdings and other things like that, unemployment, workers' comp. It's not an easy process and it's not a small undertaking, but there's simply no way around it. So getting back to your issue, yes, AI. I've been on.
Well, actually, I'm going to interrupt you on that if I can, because
Sure.
some questions came in actually on all the states about charitable registration. So you were just talking about the corporate registrations, but there's also the charitable registration issues that arise as well.
Yeah, so this is only for C3s, but if you're a C3 and if you are regularly soliciting residents of a state for charitable contributions, then there are approximately 40 states in DC that require you, before you solicit residents of that state for charitable contributions, to register with the state for charitable solicitation registration purposes. And a few of those state requirements actually also require that you qualify to do business as a foreign corporation in that state. It's a slight intersection of those two issues. But if you're a C3 and if you're doing any sort of broad solicitation nationwide, you're going to have to undertake that process. It's not simple. We don't do that ourselves, for instance, at our law firm. Most law firms don't because we can't do it cost efficiently, but there are several big companies that do this pretty well. And it's going to generally run you between their fees and filing fees around $7,500 a year initially, and then each year after that. So let's move on to AI. A lot of issues here. We don't have much time. So one thing to keep in mind is that, and we're generally talking about generative AI, things like ChatGPT. Now, there are a lot of different potential risks here, but some of the risks, not all of them, some of them can be mitigated by whether you have like an enterprise AI system, that's basically self-contained within your organization. So I'm not talking about individual users just going on their web browsers and going on to ChatGPT, but you pay for a license for an enterprise version of ChatGPT or some of the other generative AI platforms. If you do that, you have a lot of control over it. And for instance, you can make sure you can elect to have features that say whatever inputs get put into the AI platform, it doesn't go out into the AI platform system for them to use in their machine learning in the future. It kind of stays self-contained within your organization. Now, with some of the more subscription-based generative AI platforms that any of us can access, you can choose to do that as well. If you can activate those sort of features, that's going to mitigate some, not all, but some of the risks. Things like putting in information that later gets shared elsewhere, and then you get a claim that it infringed someone else's copyright or something like that. You can help mitigate those risks or data privacy concerns. You put some sensitive confidential data in there, it gets out there into the ether, and you get some claims for breaches of various data privacy laws or whatnot. That will not happen if you kind of turn off the ability for that stuff to be shared. But even if you're going to just allow individual employees to do this on their own, it's going to be too hard to regulate that, in my experience. You certainly could have a policy that says that you can only use this platform and you have to elect to turn off this feature. But that's one thing to keep in mind. Second thing, even on the output side, asking questions or putting in data and then having it spit out outputs to you, there's a lot of different potential risks. Here's a few of them that I'd highlight. And by the way, there's a pretty recent article of mine on this topic on our website under the publications tab. One is discrimination. So AI platforms have inherent built-in biases, and the platforms are doing everything they can to try to mitigate those biases, but they're built in. And if you are utilizing AI without any proper checks and balances, for instance, there's a lot of larger employers that are using it in the hiring process to screen resumes, to screen recorded interviews of potential employees. And if these built-in biases are ending up having a discriminatory impact or effect on your hiring process, that's a big concern unless you're doing everything possible to counter that. Tort liability. You're using AI to help you set standards or guidance for professionals in your industry or other things like that. And if you're relying on AI without appropriate checks and balances and doing your due diligence and things like that, you're potentially putting out guidance to the membership or to the public that's flawed, that's negligent, that's deficient, that could end up getting your nonprofit organization sued for negligence. Same thing goes for copyright infringement and for trademark infringement, copyright in particular. There's also a requirement in the Copyright Act that in order for something to be subject to copyright protection, it has to be, this, among other things, the subject of human creation. If something just comes from an AI platform that's not the subject of human creation, that's not going to be eligible for copyright protection. Those are some of the legal risks. There are some others involving data privacy and security and whatnot. But one important final thing to keep in mind is that you want to make sure, just had a client yesterday reach out and ask me for some help in developing an AI usage policy for her employees in her nonprofit organization. You have to address this now. Whatever you're going to do, and telling your staff to not use AI is probably not a realistic approach. But you have to have an AI usage policy for your employees, potentially for your volunteer leaders as well, but especially for your employees. It says do's and don'ts and checks and balances and everything else. We're seeing it increasingly having AI provisions written into contracts, with vendors, contractors, consultants, having it being written into speaker and author agreements. I'm seeing a lot of we have a lot of associations that publish journals in different medical and academic specialty fields, having kind of AI disclosure requirements if AI was used in any way to generate the journal article or whatnot. So these are all things that you want to pay attention to.
Awesome. Starting to talk about terminology and words we never thought we'd be using, right? Yeah. And jumping into another topic that's kind of front and center for many is diversity, equity, inclusion, DEI. And we had some questions there about what you're seeing out there as far as any lawsuits related to DEI and whether there's any impacts on nonprofits' mission in regards to DEI lawsuits.
I don't know about impact on mission, but I will say there are potential liabilities that arise in this area. And this is actually the most recent article I wrote. It's called Mitigating the Legal Risks of Associations, ESG, and DEIA Programs. I'd encourage you to take a look at that if you're interested in this. So there are definitely some legal issues here, and some of the biggest ones stem from the U.S. Supreme Court's June 2023 kind of companion decisions in the cases against Harvard and University of North Carolina in connection with use of affirmative action in college admissions. And as many of you know, that case essentially involved reverse discrimination and said that it's unlawful for colleges and universities like this to consider race as a condition and giving any sort of a race-conscious advantage to student applicants due to their race, and that is illegal discrimination against individual student applicants who are not in that race. Now, while that decision applies only in the higher education context, the rationale behind that decision involving kind of reverse discrimination generally has spawned a whole rash of lawsuits, including a number by the same organization called Students for Fair Admission, where the same individual who's behind that group, he has some other nonprofits, and he has filed a number of lawsuits, some of these class action suits, but a number of lawsuits basically utilizing the same reasoning of the court to challenge the use of race and other characteristics in the hiring process from an employment law perspective. And while, like right now, for instance, under existing law, and this is all potentially subject to change depending on how these courts, these cases, as they work their way through the court system and ultimately make their way to the U.S. Supreme Court, this may change. But right now, for instance, in your hiring process, in your nonprofit, you are allowed to take race into account if members of a racial minority were previously excluded from a job category, or to remove obstacles such as unconscious bias that prevent employers from having a more diverse workforce. Now, those kind of exceptions and allowances for utilizing race in the hiring process may or may not change. Right now, that is still the law of the land. Obviously, pay attention to district court and federal appellate court decisions in your region, because that might change the law in that area. But it's certainly made employers generally, including nonprofit employers, gun shy about those utilizing race and other protected characteristics in the hiring process in that way. And the decision itself is putting even more pressure on programs that are probably now on more questionable legal ground. Things like staff leadership acceleration programs or internship programs that are open only to members of underrepresented minority groups. Now, that's on the employment law side. The same rationale is also being applied in some other cases that have been filed. For instance, the same organization filed some lawsuits against two of the largest law firms in the country, claiming that their fellowship programs, which are open only to members of certain minority groups, are a violation of what's called Section 1981 of the original Civil Rights Act of 1866, which prohibits racial discrimination in contracting. So this is contracting. This is well beyond employment. And in contracting, and because almost every scholarship, fellowship, things like that program is always going to involve a contract, what the cases say is that if you're limiting these programs, to certain minority groups only, and for instance, excluding white individuals, that is illegal discrimination on the basis of race, and that's illegal under the rationale of the U.S. Supreme Court's June decision from last year. So again, right now, I'm not aware of any court decision that has ruled in favor of the plaintiffs in those cases, but it is absolutely something to keep an eye on. One more thing, and then we got to move on. Right now, this is only the case in Florida, but I expect this to expand, and particularly into other red states. Florida has a law that took effect in July of 2022 called the Stop Woke Law, or that's how it's kind of referred to. It's called the Individual Freedom Act, which restricts diversity-related training in any private Florida workplace. So you cannot do DEI trainings, arguably even unconscious bias or sensitivity trainings in Florida-based nonprofits. And this also presumably includes any nonprofit that's holding a meeting in Florida, and presumably includes any nonprofit that has an employee who is remote working from Florida. So if you have mandatory DEI related trainings that you do for your staff, and one or more of your staff are located in Florida, it is illegal for you to provide those trainings to those individuals in Florida. Some other states like Texas have a similar law, but it's only limited to government agencies, to state government agencies. But like I said, I fully expect these laws to expand in the future.
Okay. Thanks for that. That was a lot going on there. Switching topics again, because that's what we keep doing, just switching topics. What advice do you have regarding negotiating hotel contracts and event cancellation insurance, especially when it comes to exclusions related to COVID or other pandemic type events?
Yeah, so if you had asked me this, I guess 4 years ago now, my law partner Nisha and I started Tenenbaum Law Group 4 years ago. January of 2020, 2.5 months in, pandemic hits, and particularly in the association community, which holds, huge, so heavily involved in meetings and conferences and conventions. All of a sudden, so many states, shut down the ability for large gatherings, and so they had to cancel these conferences. No one even really knew what force majeure meant. They all learned about it really quickly in 2020, and we were able to get most of our we were able to get all of our clients kind of out of their contracts without paying cancellation penalties in 2020. It got a lot more difficult in 2021 as states started to lift those restrictions. And while Nisha and I have done entire sessions on just meeting contracts and things like that, I will say that we learned a lot, but it also grew our firm significantly. We probably signed up 150 associations in 2020 who wanted us to help them with their hotel and convention center contracts, and many of them stayed with us for so many other areas. But we learned so much about that now we have so many things that we kind of factor into our hotel and convention center contract negotiations to try to give every advantage to our nonprofit clients as possible. Meeting cancellation insurance was a godsend for organizations that had it prior to the pandemic. Since the pandemic, actually starting in January of 2020, the leading carriers of event cancellation insurance provided wrote in exclusions for COVID and other similar pandemics. So you can no longer get event cancellation insurance for that. But event cancellation insurance is still very important. Think of hurricanes and storms and other things that we're seeing all of the time, flooding, wildfires. There are other things that event cancellation insurance can help you protect against. Just understand the premiums have gone up significantly, as have all insurance premiums in the last few years, but especially event cancellation insurance. But if you're an organization that relies heavily, say, on a huge annual meeting that constitutes 30% of your budget, you really need to consider acquiring it.
Awesome. Thank you. Being cognizant of time, I'm going to do one last short question, or at least the question short. We'll see what the answer is. But is it all right to pay board members a small stipend?
So first off, from an IR, we got to always analyze it. This is how my brain works, at least. When I get a question like that, I think, all right, what areas of law apply? And then, how do we go about executing on that, answering the question? So first, from an IRS perspective, there's no prohibition on paying board members, but there is a prohibition on what's called private inurement, which means paying more than fair market value compensation to insiders, such as officers, directors, and senior staff. And so from an IRS perspective, so long as it's not greater than fair market value, and there actually are some compensation studies out there for nonprofit board compensation. Not a lot, but there are some, so you can get an idea of what fair market value is. And as long as you're paying under that, it is permissible from an IRS and a private inurement perspective. But as I said earlier, that does have to get disclosed on the Form 990, which is a very public document. And it's something that may or may not be a red flag to the IRS, depending on the amount of the compensation, but certainly could be a red flag to the general public and potential donors and whatnot, again, depending on the size of the compensation. From a state law perspective, as far as I remember, I think there might be a couple of states that address this and prohibit it. But most states do not, in their state nonprofit corporation laws, do not prohibit compensating directors. There's generally a requirement for all compensation that it be reasonable, which basically means fair market value. But generally speaking, it's going to be permitted. One other thing to keep in mind, someone asked me about this recently. There's a law that's been around since 1997, the Federal Volunteer Protection Act, that says that there's some broad blanket immunity, liability immunity protection for unpaid volunteers, and it carves out reimbursement of expenses. Unpaid volunteers of nonprofit organizations. And then every state has to have a state volunteer protection law that provides no lesser protection for its volunteers. There are, of course, some exceptions for really bad behavior, intentional misconduct, criminal violations, et cetera. But it's a really important protection. I always talk about it when I'm doing board trainings. And that is one thing to keep in mind. If you're getting a stipend, you're getting compensated as a board member, you're not going to be subject to protection under the state or federal volunteer protection laws. But there's still a lot of other layers of protection, such as the corporate status of the organization itself, which provides a corporate shield, an indemnification provision, most likely in the bylaws of the organization, and your directors and officers liability insurance. I know we're pretty much at the top of the hour, and I am sorry I was not able to get to everyone's questions, both ones that were asked here in the Q&A and those that were submitted in advance. If any of you still have an interest in having me answer those questions, feel free to email me. If Liz or Pat or John, if someone can, there's my email. Yeah, there's my email address on that slide. Feel free to email me, and I'll do my best to get back to you with answers to your questions. And if I have articles or recorded webinars that address the topic, I will be sure to send those to you as well. But I want to thank you, John and Pat and Liz and CohnReznick and Christina for the opportunity to be here today and answer your questions. And maybe we'll do this again 6 months or a year from now, and we'll get to a whole other series of questions. But I appreciate the opportunity. Thank you very much.
Well, thank you very much. Yeah, thanks, Pat. I'll close us out here. Jeff, thank you very much for moving so quickly and so thoroughly through all of those questions. I'm sure our audience appreciates them very much. We appreciate it very much, and appreciate very much having you here. So as I think all of you know, we're at your service here, and feel free to call Pat or me if you have any questions. We're happy to help as well. For more information about our not-for-profit ministry practice, please visit the web pages on your screen. Our webinar series will continue again in June. Please be on the lookout for the topic and the invitation and a date. We want to hear from you. If there is a topic you would like our team to present in the future, please message us via the Q&A widget here, or send us a separate email. We very much want to hear from you again. So again, thank you very much for attending today's webinar. As we mentioned earlier, your CPE certificate will be available for immediate download if you viewed the webinar for at least 50 minutes and responded to at least 75% of the attendance checks. There is a survey at the conclusion of the webinar. We'd really appreciate your feedback. An on-demand version of this webinar will be available approximately 2 hours after this webinar ends and can be accessed using the audience link that was sent to you earlier. Thank you, everyone, and enjoy the rest of your day.